Today we'll talk about promoters. Promoters finds its definition in Section 2, subsection 69 of the Companies Act 2013. Now, according to the definition of promoter, that is Section 2, subsection 69, a promoter means a person, number one, who has been named as a promoter in the prospectus or is identified by the company in its annual return referred to in section 92. Second, a promoter means a person who has control over the affairs of the company, either directly or indirectly, as a shareholder, director, or otherwise. Third, in accordance with whose advice, directions, or instructions the board of directors of the company is accustomed to act. Now, for a second, let's take a look at section 2, subsection 76. It talks about the definition of a related party with reference to a company. Now, clause 7 states that related party with reference to a company means any person on whose advice, directions, or instructions a director or manager is accustomed to act. Look at this definition of promoter, the third part. Promoter means a person in accordance with whose advice, directions, or instructions the board of directors of a company is accustomed to act. Now, both of these two definitions are on similar lines, and thus a promoter is a related party with reference to a company. Section 188 talks about the restrictions on related parties, and therefore these restrictions in Section 188 apply to the promoter as well. Now, to the definition of promoter, there is a proviso clause which states that nothing in subclause C shall apply to a person who is acting merely in a professional capacity. The question arises is then what is or who is a person acting merely in professional capacity? Now, a person who acts in a professional capacity is not a promoter. For example, a solicitor. A solicitor prepares the primary documents for the proposed company on behalf of the promoters, but he is not a promoter. Any other person, can become a promoter if he helps in the formation of a company by doing an act outside the scope of his professional duty. For example, he may help in getting a purchaser for the company shares, or he may help in getting personnel for the company. Such acts make him a promoter. Now let's move on to the duties of the promoter. The first important duty is the promoter is in a fiduciary position, and this was brought out by Lord Keynes in Erlanger versus New Sombrero Phosphate Company. According to Lord Keynes believed that promoters stand undoubtedly in a fiduciary position. They have in their hands the creation and molding of the company. They have the power of defining how and when, in what shape and under what provision the company shall start into existence and begin to act as a trading corporation. In another case of Omnium Electric Palaces Limited versus Baines, it was held that the promoter is in a situation akin to that of a trustee of a company, and his dealings with it must be open and fair. Now, what is this open and fair that they're talking about here? So it stated thus, the first and foremost duty of a promoter is that if he starts a company for the purpose of buying his property and wants to draw his payment from the money obtained from shareholders, he must, that is, the promoter must faithfully disclose all facts relating to the property. If he conceals any fact in relation to the character or value of the property or his personal interest in the proposed sale, The company will then be entitled to set aside the transaction or recover compensation for its loss. The promoter is guilty of breach of trust if he sells property to the company without informing the company that the property belongs to him, or he may commit a breach of trust by accepting a bonus or compensation from a person who sells property to the company. Now, does this mean that the promoter cannot sell his property to the company? Of course, he can sell, but he has to disclose it. The next question, therefore, is to who shall he disclose? And this was answered in Erlanger versus New Sombrero Phosphate Company, where it was held that this disclosure must be made to an independent and competent board of directors. Let's take a look at the facts of this case, Erlanger versus the New Sombrero Phosphate Company. Now, a group of persons headed by Erlanger purchased an island containing phosphate mines for £55,000. A company was then incorporated to take over the island and to work the mines. Erlanger named 5 persons as directors. 2 were abroad. Of the 3 others, 2 were persons entirely under Erlanger's control. Now, these 3 directors purchased the island for the company at a price of £110,000. The prospectus was issued, many persons subscribed to the shares. The purchase of the land was adopted by shareholders at their first meeting, but the real circumstances were never disclosed to them. Now, the company failed and the liquidator sued the promoter for a refund of the profit. Now, the promoters contended that the company's board of directors had full knowledge of the fact, and because they had full knowledge of the fact, the promoters were not guilty. But Lord Keynes said that if the promoters propose to sell their property to the company, it is incumbent upon them to take care that they provide the company with an executive body who shall both be aware that the property which they are asked to purchase is the promoter's property, and 2, who shall be competent and impartial judges as to whether the purchase ought to be made or ought not to be made. Now, it's not always possible that the promoters can give the company an independent board of directors. In a private company, it's not possible. Even in a public company, for example, Salomon and Company, which consisted of only family matters, it was just not possible to constitute a board of independent directors. So what happens in such a case? In such a case, the promoter should disclose his interest and profit to the shareholders of the company, and not just a few shareholders, but all the shareholders. And this was brought out in the celebrated case of Gluckstein versus Barnes. Let's look at the facts of this particular case, Gluckstein versus Barnes. A syndicate of persons was formed to raise a fund, buy a property called Olympia, and resell it to a company. They first brought up some charges upon the property for sums below the amount which the charges afterwards realized, and thereby they made a profit of £20,000. Now, this syndicate then bought the property for £140,000, formed a limited company, and then resold the property for £180,000 to the company, of which they were the first directors. They issued a prospectus inviting applications for shares and disclosed the 2 prices of £140,000 and £180,000. But they did not disclose the profit which they made earlier of £20,000. Now, shares were issued, but afterwards the company went into liquidation. Now, it was held the promoters ought to have disclosed to the company the profit of £20,000. Now, one of the defendants, who was the promoters arguing on his for himself, contended that this fact of that earlier £20,000 profit was known to the parties of the transaction. But Lord Halsbury had nothing to do with it. He said that it is too absurd to suggest that a disclosure to the parties to this transaction is a disclosure to the company. They, that is the the parties to the transaction were there by the terms of the agreement to do the work of the syndicate, that is to say, to cheat the shareholders. We now move on to the liability of the promoters, which are seen in the Companies Act 2013. We look at section 35(1)(c). Section 35 talks about the civil liability for misstatements in the prospectus. Section 35 subsection 1 states that where a person who has subscribed to the securities of a company, acting on any statement which is included or inclusion or omission of any matter in the prospectus which is misleading, and has sustained any loss or damage as a consequence thereof, the company and every person who, we look at section 35 1 subsection C, the promoter shall be liable to pay compensation to every person who has sustained such loss or damage. So what section 35(1)(c) is saying basically is if there is a misleading statement in the prospectus or some omission is not there which is relevant, and a person subscribes to the shares, the securities of the company, then the company and every person responsible, which includes the promoter, will be liable to pay compensation to such person. Let's look at section 39, allotment of securities by the company. Now, section 39 states that when a company issues a prospectus, all the money which it receives from people who apply for the shares, that money should be deposited in the scheduled bank. Now, if the entire amount payable on application for shares in respect of the minimum subscription as stated in the prospectus has not been received by the company, then all the money which it has collected must be returned to the applicants. Now, this is where it becomes important. If there's any contravention to this provision, the company and its officers, and thereby the promoter who are in default, they shall be liable to penalty for each default of rupees 1,000 for each day during which the default continues, or rupees 1 lakh, whichever is less. So if the money is not returned to the applicants, then the promoters are held liable. Let's look at section 300 of the Companies Act. Now, section 300 comes under the sections which talk about the winding up of the company. Now, section 300 in our particular case with respect to the promoter states that if the tribunal has passed an order for winding up the company and the liquidator has made a report to the tribunal that, in his opinion, a fraud has been committed by the person, among other things, in the formation of the company, then the tribunal can order such a person, which includes the promoter, to be examined by the tribunal. And these are some of the explicit liabilities of the promoter as per the Companies Act 2013.